Let us understand and discuss the third and fourth issues to be considered in Ijarah contract. The third issue is with respect to the maintenance of the lease asset. And this refers to the liabilities or obligations on the part of either the lessor or the lessee. The lessor bears the risk of undeliberate loss or destruction of the asset as part of the ownership risk. And the lessor also bears the risk of depreciation, taxes, and insurance of the lease asset. However, the lessee is a trustee and has a fiduciary responsibility to protect the asset. The lessee also bears the costs related to current expenditure necessary for utilizing the asset during the lease period. The lessor can demand some form of security. And if there is damage or the lessee defaults on rent, the lessor can recover the cost from the security. However, any amount in excess of such cost is riba or usury, which is a major prohibition in Sharia or Islamic law. The fourth issue to be considered is as regards sublease by the lessee. The Islamic law permits sublease by the lessee only as provided by the lessor, or when the lessor permits as provided in the agreement. It is not objectionable whether the rent is equal to or less than the rent payable to the original lessor. However, it is not allowed if the sublessor invites others to share rentals without transferring partial ownership. And it is also not allowed if the sublessor charges a fee to partners for sharing the rentals.